Hello, it's Kip Malek, workers' comp lawyer at Malek and Malek Law Firm. Today I'm going to be talking about how to value the settlement value of your case. And why am I bringing this up? Because occasionally we'll get calls from prospective clients, and their issue will kind of come down to this. They're represented by some other attorney. Their other attorney and them have entered into settlement negotiations either with the employer and the attorney general, or via court case, or a settlement with the BWC, and they've gotten some indication from their attorney about the value of their case, and that individual, the injured worker, they'll call us and be like, well, here's the facts. I feel like my other attorneys, undervaluing or underselling my case. Is this, what do you think? And so we're not in the business of stealing other attorneys' clients, and I would say probably 90 to 100% of the time, 99 to 100% of the time, most injured workers, BWC attorneys, at least in the Columbus area, they're not out there to throw you under the bus or screw you. So, but maybe it would have helped, or maybe it would help if you understood or understand how to value your case, and then you could say, okay, maybe I should settle, or maybe I shouldn't settle. Maybe I should continue with my case, and then you could, if you're more informed, then you can make a more informed decision. So what I'm going to do is I'm going to give you a brief overview, and then what I'll probably do in this is I'll break down a couple of examples of how you value your case, and I'll do that with like an overhead type of thing. So work through some values and the math behind how to value your case. But as far as an overview, so first, folks will get injured and they'll ask, okay, I want to settle my case. You can't just go up to your employer or whatever and say, hey, I want to settle my case, throw some money at me. Sometimes they do, but sometimes the employer will not want to settle your case, particularly if it's pending through the BWC process. And what I mean by that is you've got injured, you have an allowed claim, you're either receiving comp and medical treatment, and it's still within the experience of the employer. So and when I say within the experience of your employer, anything that happens within your workers' comp claim will have an impact on their BWC insurance premium. So, and what would have an impact on their insurance premium would be settling your case. That'd be a possible big impact for them. And so if you submit, say, a demand, it's called like an administrative settlement. So you submit a demand at the administrative level, at the BWC level, then they have to sign off on it if it's within their experience. And it's like, between 4 and 5.5 years. It could extend longer, but it's generally those are the lengths. And it depends on which part of the year. If you're the first half of the year, the second half of the year, depending on what that time frame is. So if it's still within their experience, then they'll likely not sign off on it. It could be a weird circumstance where your claim there's been so much comp and medical bills paid out that their contribution to your claim has reached max value. So once it reaches max value, there's no other impact to that employer in terms of their BWC insurance premium. So then they kind of might not care in that instance as well. But most of the time, and I'm talking about a circumstance in this particular video where you either have gone through the administrative process, and what I mean by that is it's either been allowed or disallowed by the BWC. They've issued an order, somebody's appealed, you've gone to hearings, DHO, SHO, whatever, and your claim has been denied entirely. So your work injury claim has been denied entirely, or your claim is allowed, but you're trying to get an additional condition added to your claim. So in those instances, and it's been denied. So in those instances, you and or your attorney on your behalf will have filed a notice of appeal and a complaint to the Court of Appeals in whichever county your injury happened to occur in. And what that would do is that would take the case, and it would go to court, and then when you file a case either to allow your claim or regarding an additional condition, you're filing a lawsuit not only against your employer, and it's not really a lawsuit, it's just workers' comp suit, but against your employer, but the other party will be the BWC. And so the Attorney General for the workers' comp section will represent the BWC, and your employer's attorney will represent your employer. And then so what happens then is you'll go through discovery. There'll be depositions of your expert. It could be a lot of depositions. It could be not so many depositions, depending on how complicated or not complicated your case is. But inevitably, it may come down to it may come to the point where it's like it might make sense to settle this. So we'll draft a settlement demand, and then we'll send that to the Attorney General, ask for what's called a settlement conference, and then that settlement conference, there'll be basically a dialogue between the Attorney General, a representative from the BWC who's basically going to be signing off on any settlements, and then a representative for the employer who also has to agree to the settlement value as well. And so what we do, we'll go on the settlement demand. We'll submit a settlement demand, and we'll basically lay out what we think the value of the claim is, and then and why that value is substantiated through this claim. So how do we come about that, the actual background? What comes into setting that settlement value? On a soft value is the possibility of success at trial. So if there's very little success, then we attribute, we might discount the actual number we're requesting. But if it's very unlikely, then we'll discount it based upon the unlikelihood. It's very likely, then we might boost up the percentage. But really, that why I say that's a soft value, because it's kind of neither here nor there as far as the value of your claim. The value of your claim, so let's go with the first scenario. It's not a allowed claim. It's a completely denied claim. So you've gotten, for this example, you lifted a box at work, and you allegedly suffered a lower back injury, lumbar sprain. So, and the value would come from what medical has been paid out. So presumably that would be your urgent care, emergency room visit, maybe a few follow-up visits or more with a BWC doctor, maybe some physical therapy that you've had while your claim was pending, and maybe some medication. Who knows how much that is? It could be a few thousand, could be more. And then how long were you off from the date of injury and up until, like, say, the date of the settlement? So we'll figure out how many weeks that was, and we'll assume that you would have been paid temporary total compensation for that time. So we'll throw that into the kitty as well. And then we'll also, so that's past comp, past medical. Then we'll consider future comp and future medical. So if we're trying to get a lumbar sprain, but it looks like it's more serious, like for instance, you may have indications that you have a herniated disc, that's more prospective. If you don't have the diagnostics yet, we would just be focusing on lumbar sprain. So lumbar sprain is a soft tissue injury. So to pad it, we might throw in, assuming the claim's allowed, you might receive an additional X number of weeks of comp, and then you might receive more medical treatment in the form of like diagnostics, like an MRI, an X-ray, an EMG, etc., to figure out what's going on with your back. So that will all come into the calculation. So they'll figure that out. How much is that? And then maybe we'll throw in the kitty as well. A permanent partial disability award. How much would you get for that? And then we might look prospectively out even further. What additional conditions may be additionally allowed in this claim? And that's when you get more speculative. That's again more of a soft number, and it really is not going to have an impact one way or the other. And then we take all those numbers. We do actually do math problems or math calculations, and we take your wage rate and we calculate how much your comp would be worth and this stuff. Again, we hand that to we bring that with us to the settlement negotiation, and we banter that back and forth. So that would be a pending claim that hadn't been allowed yet. So let's say you have had a claim that's been allowed, and let's for the sake of argument, you had a work injury. You've been off for a couple years. You injured your right shoulder. You've had a rotator cuff tear. You had a rotator cuff repair. You've had a bunch of physical therapy, a bunch of maybe you've gone to a pain management consult. You've had a number of diagnostics done. So there's quite a bit of medical bills involved with this claim already, because you've been overcompensating with your left shoulder because your right shoulder has been basically immobile for a while. You develop like a left shoulder sprain on a flow-through basis. So what we do, we try to get that allowed, the left shoulder sprain on a flow-through basis at the administrative level. Again, DHO, SHO. For the sake of this example, it's been denied. So you have an allowed claim for right rotator cuff repair. You've had a significant amount of treatment. You've been off work since the date of injury. You haven't returned to work, and now you have this left shoulder sprain pending in court. So in that instance, and I think this is where some of the frustration comes in with injured workers, is what ends up happening is they think, since they've been off work for 2 years and they've received all this medical treatment, that the more stuff that has happened or been paid out, the more value their claim should have. And it has, that kind of serves as an indication of that this is a serious claim, but it's not like a multiplier of the value of your claim. And in fact, let's say you had a rotator cuff tear and it's been repaired, and you're more or less, you're doing pretty good, and you may or may not have this left shoulder thing, and maybe it is just a left shoulder thing. So realistically, you've had, and let's just say for the sake of argument, you've had hundred plus thousands of dollars in medical treatment paid out, and you've received $80,000 in compensation paid out, and you're thinking, okay, I want to settle this. I have $180,000. That should be at least worth $200,000, $300,000 because it's such a serious. Well, in fact, in this instance, it may not be worth anything or very little. I mean, everything's worth something, but because the value of the claim has been paid out, so it's not. You can imagine like it's a balloon. Like you blow up the balloon. So when your claim's allowed, you blow up a little bit of air in the balloon, and every time you have any treatment or comp, you withdraw some air from the balloon. So you had this rotator cuff injury allowed, and then you had surgery authorized. So your balloon would have been pretty big, but you've been withdrawing value from it by receiving comp and medical treatment. So the future value of your claim is, there's not a lot of future value, because maybe the left shoulder sprain isn't really, maybe it's a legitimate left shoulder sprain, but it's merely that, and then your right shoulder for the most part is doing okay, and you may not be able to 100%, but you're 90%, and you realistically should be able to go back to work, maybe after participating in vocational rehabilitation or something to that effect. So I think in that instance is when injured workers, they get back a demand that's less than what they thought they should get. I think that's where the confusion comes in. Now, if it turns out you have a rotator cuff and you have you have a more serious injury like an osteoarthritis, and also that looks like there's a possibility that you might have like a site condition that may exist. Then you start looking, and it doesn't look like your shoulder's getting better. And in this rotator, this right shoulder osteoarthritis looks like it legitimately might be added to your claim, and you might be an older individual. So then it looks like maybe you're venturing into permanent total disability territory. Then you have to factor that in. So then in that case, it's like, well, maybe it is worth more because there's these things pending out there. So really the value is not in the past. So the past is the past. You got the value of your claim is the future value, basically. And what the BWC is doing is they're not paying you. It's not like they're paying you to compensate you for the seriousness of your injury. They're paying you to limit their exposure going forward. So it's basically they're saying, okay, we'll pay money to close this claim because there's a possibility it may be worth this much in the future. We're going to pay you a discount on that future value, so it'll go away. And it's kind of a risk. Maybe there's not will not be comp paid out in the future, or maybe it'll be a substantial risk that it's going to happen. The bigger the risk and the more likelihood that you're going to pay more money out in the future, the more value there will be. The less likely, the less money that you're going to be. But in a nutshell, that's how they determine the value. So people really kind of get pissed off when they've been seriously hurt and they've been off work for a while, and there's these other factors coming. But the purpose is not to recognize the seriousness or punish the employer. It's really to mitigate their future exposure, and that's why there's no punitive damages. There's no economic damages. This is not a personal injury type of settlement value. So where you might have punitive advantages in these sorts of things, if there's like personal injury type of case where you're getting run into by a car or a truck, and there's things that they didn't do that they should have done, and you've received certain kind of injuries, and those damages could be in the upper hundreds of thousands of millions. An equivalent kind of injury in workers' comp is going to be cabined in by the value of the future comp and future medical. And so should they be paying more? I mean, I would argue they should, but that's the way that the system is, and that's the fencing that we're having to operate in. So that's basically an overview of how you get the settlement values in this first part of this video. In the second part, I'm actually going to go through those examples of the lower back guy and plug in the numbers, and then show you how maybe I would value that case, like realistically value it. And then you could see with that, maybe you'll have a better understanding. Okay, this is how I got to do this. So that's my goal in this video. So keep on listening, and then we'll go over that. Thank you. All right, this is the second part of the video where the first video I've talked about an overview of how your settlement values are calculated. In this video, which is it's going to be a theoretical injured worker called Joe Bob, and this may be how I would come about calculating a settlement demand for Joe Bob. So for the sake of this example, the date of the settlement demand that I've drafted would be today, the date of this video. So it's February 7th, 2020. So for this example, the claim, went to both the DHO level and the hearing level. It's been filed under the Court of Common Pleas. There was a notice of appeal and complaint filed, and the condition that we're going to pursue theoretically in the Court of Common Pleas would be to get the claim allowed and get it allowed for a lumbar sprain. So it's not a huge injury, not a serious injury, but Joe Bob did allegedly injure his lower back. So We filed it. We've requested a settlement conference with the Attorney General, who's been assigned to the case, and the employer, and so a date has been set. So I've got to draft a settlement demand for Joe Bob, which is going to be essentially what the money we're trying to get to settle the case if Joe Bob indeed wants to settle the claim. So to that end, Joe Bob was injured on September 18th, 2019. I guess he was working at a logistics warehouse. He'd been over, picked up a box, and then he felt pain in his back. He filed a claim. Again, it was denied administratively at the DHO and SHO level at the Industrial Commission. Since that time, he has not returned back to work. His medical bills consist of the ER visit, which he made on the date of injury. He had followed up with a BWC doctor. He's had roughly 12 sessions of physical therapy. His full weekly wage is $750. And for the first 12 weeks of comp, the comp is paid at 72% of the full weekly wage. His average weekly wage is $542, and after the first 12 weeks of comp is paid at a rate of 6.6 2/3% of AWW. I'll make a video, and I may already have made one, but I'll make a video in the future explaining what these things are: the full weekly wage and average weekly wage, how the BWC calculates those that wage rate, because the significance for you is that's how much you're going to be paid in comp each week, temporary total disability comp. So your goal is to get that higher, because if you get higher, you'll get paid more comp. And if the BWC sets it low, there's ways that you can raise your wage rate, which is something that we do quite a bit, and then previously paid comp will be paid at that higher rate if it's reset. So this is the background on Joe Bob. So the next thing is, in creating demand, we got to consider what future medical treatment may be authorized if the claim's allowed at trial. So if he prevails at trial, then we have to consider what future medical things he may undergo. So in this example, we thought, okay, he hadn't had a diagnostic, so he hadn't had an MRI, so maybe a lower back MRI, maybe a consult with a back specialist, maybe additional physical therapy. And then even more into the future, if the claim's allowed, we have all this diagnostic, maybe as a herniated disc at L5S1, maybe that's going to necessitate surgery. That is very speculative, so that very well may be the case, but for the sake of a settlement demand, you got to base it on concrete information. So it's at this point in time, in regard to the settlement demand, it's very speculative. Joe Bob hasn't sought out a lower back MRI or an ortho consult, even outside his claim. So for the sake of argument, Joe Bob has his own personal insurance. Had he wished to pursue this treatment outside the claim, he could have. He has not. His desire is to see if the claim is allowed to pursue through his workers' comp claim, if it's allowed. So these are the future medical stuff that we're considering in the creation of this settlement demand for Joe Bob. So now we get to the nitty-gritty of the numbers. So his total past medical bills is about roughly $6,000. So that's roughly $6,000. Total past comp. So we're considering the time frame. So he was injured September 18th, 2019. So we would request temporary total comp be paid from September 19th, 2019 to February 7th, 2019, which is approximately 20 weeks. His future medical bills, we're figuring maybe about $5,000. Future comp, we'll figure if the claim's allowed, he may receive 30 more weeks of temporary total compensation. And then, assuming again the claim's allowed for a lumbar sprain, we're figuring that he would receive a 5% permanent partial disability award for that lumbar sprain, and the max rate for PPD award, or max rate for permanent partial disability award for 2019 is $316.67. So these are the numbers that we use to calculate how much he may get. So okay, so this is the actual mathematics. So again, if you look up there, the FWW, this is important, is $750, and the AWW is even more important, which is 542. Again, the max PPD rate for 2019 is $316.67. So remember we had said we're gonna ask for the back comp be paid, so he would receive 20 weeks of back comp. So for the first 12 weeks, again, the first 12 weeks you're paid FWW at the FWW rate, so it's 72% of 750, which is $540. Multiply that's times 12, you get 6,480. So that's the first 12. After the first 12 weeks of TT, it switches to the AWW rate. So that's 6 and 2/3 of that AWW rate, which was 542. He'll get about $360.97 a week. So 8 times 360.97 would get you 2887.78. So the total past comp we'd be asking for is $9,367.78. So this is the past comp. Future comp. So we had said that you may be entitled to 30 more weeks of TT. So that's, again, we do that 6 and 2/3 of the AWW rate of 542 gives us $360.97. So 360.97 times 30 equates to roughly $10,829.91. So that's the future comp, and then the future PPD award, or permanent partial disability award, or also known as a C92 award, would be we're figuring he'll get a 5% PPD award. Might get less, maybe get 3%, might even get more, might get 8%. But for this example, we'll say 5%. So the way PPD works is for every percentage you get 2 weeks of temporary total paid at the PPD rate. So again, in his case, he'll get the max PPD rate for 2019. So it'd be, if you get 5%, so he'll get 10 times $316.67, or $3,166.70. So the total future comp that Joe Bob may or may not get, well, in this example, we're calculating the total future comp, and against potential, is $13,996.61. So, and this is only based upon the allowance of a lumbar sprain. We're not considering, obviously, if the claim was allowed for a lumbar sprain and he were to get diagnostics, an MRI, EMG, and then an ortho consult, and that doctor opined that he had a herniated disc at, say, L5S1, and then if we pursued that herniated disc, and if that herniated disc was allowed, and then even further in the future, if that herniated disc was allowed, and then surgery was authorized for that claim, then the value is significantly larger. But the problem is, right now we got to look at the snapshot of the information we have, and that's the only thing that the BWC and the employer will consider is the current snapshot. So with the current snapshot, this is what the future comp will be based upon the allowance of a lumbar sprain. It does not consider the allowance of, say, a hernia disc, which you may contemplate may be there, may not be there. That is only considering the lumbar sprain, soft tissue injury. Okay, so that's potential future comp. So let's look. So to get our settlement value, we have the past medical paid through the claim, the future medical, which we're considering may be paid through the claim. The past medical, obviously those bills, if it's directed at the lumbar sprain, obviously that if the claim was allowed, that those would be paid through the claim. Now, past medical that won't be paid through the claim is you go to the ER for a flu. Even if it happened at a similar time frame, that has nothing to do with your lumbar sprain, so that's obviously not going to be paid through the claim. Likewise, if you have some car accident and involving your shoulder or something, that has nothing to do with your lumbar sprain, so that's not figured into. This is purely for the back injury of the lumbar sprain. So we take the past medical, future medical, again directed at that lumbar sprain, past comp, and then future comp. and then we calculate that times the chance of success at trial, and we get a settlement value. So here we take 6,000 for past medical, 5,000 for future medical, past comp of $9,367.78, and future comp of $13,996.61. Add that together, take that sum, and for this situation, we might, based upon various factors, we may bump the chance of success at trial higher, we may bump it lower. In this case, I lowered it to a little less than half, so to 40%. So calculate that number, and then the settlement value I arrived upon was $13,745.76. So, in thinking about that, so the chance of success at trial, what are factors which goes into that? So, if the injury is well documented in the medical records, if the claimant has no credibility issues, if he testifies well, then obviously we bump that off. If he's a sympathetic individual, he's able to explain things in a coherent manner. He comes across well. He doesn't have a background history of some that really kill you is if you have like some history of committing fraud, so that your credibility is shot. So if you have a prior history of committing fraud or some kind of crime like that, and it comes in, then that's going to be presented to the jury, and then your credibility as to how you got hurt is going to be lowered. If there's witnesses for the employer that say, Joe Bob, he absolutely, I don't recall seeing him at all with an injury. I don't see that there's no video evidence. In fact, he said he complained about injuring his back the week prior, moving furniture over the weekend at his house. That lowers, that hurts your credibility, and that may or may not come into trial. So then we would lower the chance of success. On the other hand, if there was video evidence, again, if the ER record was very on point about documenting how you got injured, if the doctor that we're gonna, because we'll have to have a medical expert, if that doctor is pretty good, then we might bump up the chance of success. But we'll kind of play around with that figure. But in conclusion, based upon that, that value, I might put a demand for, say, $20,000. Likely, the offer that will be made will be between, say, $9,000 at the low end, up to $18,000 at the high end. So I'd probably put a demand for $20,000, $25,000, but the actual value, which I've calculated, is probably more in the range of this 13,000 number. But it's variable, it's squishy. So that's kind of how we calculate settlement values with this example. I mean, if you guys, if you have questions about actually how you to calculate the possible settlement value of your claim, to the extent that I can, and then I'm allowed to, because if I don't represent you, I can't really go too much into your claim, but I could give you some pointers and maybe help you with the math, and maybe give you some ballpark values. And if you give me some facts about your case, then I might be able to say, okay, I'm thinking it'd probably settle for this or this. But again, this is just a basic run-of-the-mill lumbar sprain. Obviously, if you have a more serious injury, and if it looks like you might be going to be found permanently and totally disabled, obviously you're getting up in the possible six figures range at that point. But this is a run-of-the-mill soft tissue injury. This is kind of what they typically offer for these lumbar sprain situations. So hopefully you found this helpful in some manner. If you have any questions, you could either email me or post your specific questions in the comments, and I will try to get to them. Thanks.